My name is Rachel Donnelly. In the afternoon, I found the folder of old birthday cards that finally proved my father's second will was a forgery. Was also the afternoon I had exactly 3 days left before Allegheny County closed his probate case for good. I found the folder by accident, digging through a box of my father's old correspondence in the back office of Donnelly Print and Copy, the shop he'd run on Butler Street for 34 years, looking for anything at all, that might explain how a will supposedly signed 2 weeks before his death could look so little like the man I'd known my entire life. I want to walk you through exactly how I got to that back office, with 3 days on the clock, because the story of that forged will didn't start with a folder of birthday cards. It started 8 months earlier, in a hospital room, with a document nobody in my family had ever seen before appearing out of nowhere at the worst possible moment. My father, Walter Donnelly, built that print shop from a single second-hand press in 1989, the same year I was born, and grew it, over 3.5 decades, into a fixture of the neighborhood, the kind of business that printed every church bulletin, every Little League schedule, every wedding invitation for 3 generations of families along that stretch of Butler Street. My mother passed when I was 19, and my father never remarried, pouring the bulk of his remaining energy into that shop and into raising my younger brother Craig and me largely on his own. I want to be honest, before I go further, that Craig and I had a complicated relationship with our father over the years, though in different ways. I stayed close to home, went to community college, eventually took a job managing accounts for a regional print supplier, and visited my father most weekends, helping out at the shop whenever an extra set of hands was useful. Craig moved to Columbus in his late 20s, built a career in commercial real estate that seemed, from the outside, considerably more successful than mine, and visited our father far less frequently. Holidays mostly, phone calls that grew shorter and less frequent as the years went on. I don't say any of that to paint Craig as a villain from the outset, because for most of our adult lives, the distance between him and our father felt like an ordinary consequence of geography and different life paths, not any deliberate coldness on Craig's part. My father, for his part, never seemed to hold Craig's distance against him, speaking of his son with the same quiet pride he always had, even when months passed between their conversations. My father's health began declining about 2 years before his death, a slow progression of congestive heart failure that eventually required increasingly frequent hospitalizations. During one of the earlier hospital stays, about 3 years before he passed, my father sat down with a longtime family attorney, a careful, thorough man named Harold Betancourt, who'd handled Donnelly family legal matters for over 2 decades, and executed a will that split his estate, the shop, the house on Marchant Street, and his modest investment accounts evenly between Craig and me, with a smaller specific bequest to Sam Sullivan, the shop's longtime foreman, a man who'd worked alongside my father for over 30 years and had become over that time closer to family than most of our actual relatives. I want to describe Sully, as everyone called him, in some detail, because he becomes central to everything that follows. Sully started working at Donnelly Print and Copy in 1991, a young man with steady hands and an eye for detail that made him, within a few years, indispensable to the shop's day-to-day operations. He and my father developed a friendship over the decades that ran deeper than most employer-employee relationships, fishing together most Saturday mornings, sharing a running joke about the same broken vending machine in the shop's break room that neither of them ever quite got around to fixing. When my mother passed, Sully was one of the few people outside our immediate family who showed up every single day of that terrible week, running the shop entirely on his own so my father could focus on us. My father's health took a sharper downward turn about 10 months before he passed, a hospitalization that stretched from a planned 3-day stay into nearly 3 weeks, complications from his heart condition compounding with a case of pneumonia that hit him considerably harder than his cardiologist had initially expected. I visited him most days during that stretch, and Sully visited nearly every single day as well, often staying for hours, the two of them talking about the shop, about old fishing trips, about nothing in particular, the way close friends do when one of them is facing something serious. Craig flew in for exactly 4 days during that 3-week hospitalization, staying at a hotel rather than at the house, citing work obligations that required him to remain reachable and connected in ways our father's house, with its unreliable internet, apparently couldn't accommodate. My father passed 6 months after that hospitalization, at home in his own bed with hospice care in his final days. And I was with him when he passed, along with Sully, who had become by that point almost a permanent fixture at the house during those final months. Craig arrived the day after our father's death, in time for the funeral but not in time to say goodbye, a fact that weighed on him visibly. Though I never said anything critical about it directly, understanding grief affects people in different ways, and not wanting to add to whatever pain he was already carrying. The original will, the one Harold Betancourt had drafted 3 years earlier, went into probate about 2 weeks after the funeral, a routine process that Harold assured us would likely conclude within 4 to 6 months, given the relatively modest and uncomplicated nature of my father's estate. About 5 months into that process, roughly 3 months before the probate case was scheduled to close, Craig's attorney, a man I'd never previously heard of named Gerald Finch, filed a motion introducing a second will, one purportedly executed by my father just 2 weeks before his death, superseding the earlier document Harold had drafted. This second will left the print shop and the house on Marchant Street entirely to Craig, with a reduced cash bequest to me of $40,000 and no mention whatsoever of Sam Sullivan. I want to describe my reaction to seeing that document for the first time because I think it matters to understanding everything that followed. My first response wasn't suspicion. It was confusion, a genuine inability to understand how my father, in his final, most physically depleted weeks, would have executed an entirely new will, working with an attorney none of us had ever heard of, without mentioning it to a single person in the family, including Sully, who had been with him almost daily during that exact stretch of time. Harold Betancourt, reviewing the second will alongside me in his office, expressed the same confusion. "Rachel, I want to be careful here, because contesting a will is a serious legal process, and I don't want to encourage you toward an expensive fight based purely on emotional disbelief. But I'll tell you honestly, this doesn't sit right with me. Your father never mentioned wanting to revise his estate plan, not once, in any of our conversations over the last 3 years, including several conversations we had during that long hospitalization, less than a year before this document is dated. The attorney who purportedly drafted the second will, a man named Victor Reyes with an office in a different part of the county, one my father had never done business with in his entire life, provided documentation showing my father had visited his office on a specific Tuesday afternoon, 2 weeks before his death, to execute the new will with 2 witnesses present, a notary seal affixed, and Victor Reyes's own notarized statement affirming the signing had occurred properly. I contested the will formally, with Harold's help, but the process moved slower than I'd hoped, and as the months wore on, the probate court, working through a considerable backlog and facing a contest that, on paper at least, presented 2 seemingly valid competing wills, scheduled a final resolution date that, barring new evidence, would likely favor the more recent document simply by virtue of its more recent execution date, absent clear proof of fraud. I found myself, with the closing date now just under 2 weeks away, growing increasingly desperate to find something, anything, that could definitively prove what every instinct in my body already told me was true. That my father had never set foot in Victor Reyes's office. That the signature on that second will, however similar it appeared at a casual glance, had never actually been made by my father's own hand. Sully, hearing about the deteriorating situation over a phone call about 3 weeks before the closing date, insisted on getting more directly involved than he had been up to that point. "Rachel, I was with your father almost every single day during the last year of his life. If there's a specific Tuesday 2 weeks before he passed, where he supposedly drove himself to some office across the county to sign a brand new will, I think I'd remember whether that day actually happened the way this Victor Reyes claims it did. We sat down together, going through Sully's own calendar and memory as carefully as we could reconstruct it, and Sully was able to identify, with reasonable confidence, that the specific date listed on the second will fell during a stretch when my father had been almost entirely housebound, still recovering from a bout of pneumonia that had briefly returned about 6 weeks before his death, unable, as far as Sully could recall, to drive himself anywhere at all during that particular period. He wasn't driving himself anywhere that week, Rachel. I picked him up for his cardiology follow-up that same week because he wasn't strong enough to drive. I remember it specifically because it was the week the shop's old printing press finally gave out for good, and I had to handle the whole breakdown myself because your dad was too weak to come in. This was promising, But Sully's memory alone, however sincere, wasn't going to be enough to overturn a notarized legal document on its own. Harold agreed to bring in a forensic document examiner, a careful, precise woman named Dr. Elaine Vasquez, who specialized in signature analysis and document authentication, to review the second will, alongside authenticated samples of my father's actual signature from other documents around the same time period. Dr. Vasquez's initial review, completed about 10 days before the closing date, identified several concerning inconsistencies. The signature on the second will, while superficially similar to my father's authentic signature, showed subtle differences in stroke pressure and letter formation that suggested, in her professional assessment, a reasonably skilled but not perfect forgery, possibly traced or closely copied from an authentic sample rather than produced through natural, spontaneous handwriting. This isn't conclusive on its own, Dr. Vasquez cautioned. A skilled forgery examination can identify strong indicators of inauthenticity, but courts generally want this kind of finding corroborated with additional evidence, particularly given how much is at stake in this specific case. With the clock now down to about a week, I threw myself into gathering every piece of corroborating evidence I could find, working through old boxes at the shop, at the house, anywhere that might contain information about my father's actual whereabouts and activities during the specific window when the second will claim to have been executed. This is where the folder of birthday cards comes in, the one I mentioned at the very beginning of this story. Going through an old box of correspondence in the shop's back office, 3 days before the probate case was scheduled to close, I found a folder my father had kept of cards and letters from over the years, sentimental things he'd apparently saved rather than discarded. Near the bottom of that folder, I found something unexpected, a get-well card from a neighbor, dated with a specific note inside referencing a visit this past Tuesday, the exact Tuesday the second will claimed my father had driven himself across the county to execute a new estate plan. The neighbor's note described stopping by to check on my father, finding him resting in his recliner, too weak to do much more than manage a brief conversation, mentioning specifically that she'd been glad to see him resting rather than running around like he sometimes insists on doing even when he shouldn't. I called that neighbor, a woman named Patricia Nowak, who'd lived 2 doors down from my father for over 15 years, and she confirmed without hesitation the visit described in her card, remembering it clearly because it had been the same week her own granddaughter was born, an event she'd mentioned to my father during that visit, and that he'd apparently expressed genuine joy over, despite his own weakened condition. Rachel, your father could barely make it from his recliner to the bathroom that week without help. I remember because I offered to help him up when I was leaving, and he waved me off, a little embarrassed about needing the help at all, but he clearly needed it. There's no way that man drove himself anywhere that day, let alone across the county to some attorney's office he'd never mentioned to me in 15 years of being his neighbor. Patricia agreed to provide a written and signed statement to that effect, along with the original dated card, and Dr. Vasquez, reviewing this new information alongside her forensic findings, indicated that the combination considerably strengthened the overall case for fraud, though the final determination would still rest with the court. With 2 days remaining before the closing date, Harold filed an emergency motion requesting an expedited hearing to present this new evidence before the probate case could close, a request the court, given the seriousness of the fraud allegations and the newly surfaced physical evidence, agreed to grant, scheduling a hearing for the following afternoon, the last possible day before the case would otherwise have closed automatically in favor of the second will. I want to describe that hearing in some detail, because it represents, in a very real sense, the formal reckoning this entire ordeal had been building toward. The hearing took place in a modest courtroom in the Allegheny County Courthouse, presided over by a judge named Constance Ferrara, a careful, no-nonsense jurist who had clearly reviewed the extensive filings from both sides in advance and intended to move through the proceedings with considerable efficiency given the compressed timeline. Craig arrived with his attorney, Gerald Finch, both of them projecting an outward confidence that, in hindsight, I believe was considerably less certain than it appeared on the surface. Victor Reyes, the attorney who had purportedly drafted the second will, also appeared, along with the 2 witnesses listed on the document, a man and woman I had never previously met, both of whom, it would emerge over the course of the hearing, had only a tangential and recently established connection to Craig. having apparently been introduced to him through a mutual business associate in the months leading up to our father's death. Harold presented our case methodically, beginning with Dr. Vasquez's forensic analysis, walking Judge Ferrara through the specific inconsistencies identified in the signature, the subtle indicators of a copied rather than spontaneously produced authentication. Dr. Vasquez testified clearly and precisely, careful not to overstate her findings beyond what her professional expertise could support, but firm in her assessment that the signature showed meaningful indicators of inauthenticity. Sully testified next, walking the court through his own detailed recollection of my father's physical condition and daily activities during the specific week in question, the broken printing press, the cardiology follow-up appointment he'd personally driven my father to, the general housebound state my father had been in throughout that entire stretch of recovery from his pneumonia relapse. Patricia Nowak's statement, along with the original dated get-well card, was entered into evidence next, corroborating Sully's account with independent, contemporaneous documentation that had never been created with any anticipation of this legal dispute, making it, as Harold argued, particularly credible evidence of my father's actual condition and whereabouts during the disputed time frame. Victor Reyes, called to testify about the circumstances of the will's execution, grew visibly less composed as the hearing progressed. He initially maintained, with apparent confidence, that my father had personally visited his office on the specified date, walking in unassisted, discussing his estate planning wishes clearly and coherently, and signing the document in the presence of both witnesses and Reyes himself as the notarizing attorney. Under Harold's careful, methodical cross-examination, however, several troubling gaps emerged in Reyes's account. He could not produce any sign-in log or office visitor record for that specific date, despite maintaining, he claimed, standard record-keeping practices for all client visits. He could not clearly recall specific details about my father's physical appearance or demeanor during the supposed meeting, details that, given my father's visibly weakened condition at that time, one would expect to have made a notable impression on anyone meeting him for the first time. When pressed on how the meeting had initially been arranged, Reyes's account grew increasingly vague, eventually acknowledging that Craig himself had made the initial contact and arrangements, rather than my father personally reaching out to schedule the consultation, an arrangement Reyes characterized as unremarkable, but that Judge Ferrara, taking careful notes throughout, appeared to find considerably more significant. The two witnesses to the will's execution, when called to testify, provided accounts that grew increasingly inconsistent with each other under questioning, one describing my father as having walked into the office under his own power, the other describing him as arriving in a wheelchair, a discrepancy that, combined with Patricia Nowak's testimony about my father's actual housebound condition that week, cast serious doubt on whether either witness had actually been present for a genuine meeting with my father at all. Judge Ferrara, after hearing the full body of testimony and evidence, did not immediately rule, taking a brief recess to review her notes before returning to deliver a decision that I remember with considerable clarity, given how much weight that afternoon carried for the remainder of my life. This court has reviewed extensive forensic evidence indicating meaningful irregularities in the signature attributed to the decedent, corroborating testimony from a neighbor whose contemporaneous documentation was created with no anticipation of this legal dispute, and testimony from a longtime family friend regarding the decedent's physical condition during the relevant time frame, all of which stands in direct contradiction to the testimony provided by the notarizing attorney and the two purported witnesses, whose own accounts, moreover, contain significant internal inconsistencies regarding basic details of the alleged signing. Based on the totality of this evidence, this court finds the second will, dated the 14th of that month, to be invalid, and orders that probate proceed instead, according to the original will executed 3 years prior under the supervision of attorney Harold Betancourt. I watched Craig's face during that ruling, and I want to describe it honestly, because it revealed something I hadn't fully expected. He didn't look angry or defiant in the way I might have anticipated from someone confident in the legitimacy of his position. He looked, instead, like a man watching a structure he'd built with considerable anxiety finally, predictably, collapse. A kind of exhausted resignation rather than genuine surprise. Judge Ferrara, before concluding the hearing, addressed one further matter directly. Given the seriousness of the findings in this proceeding, This court is referring this matter to the district attorney's office for further investigation into potential fraud and forgery, a process entirely separate from and in addition to the civil resolution of the state itself. I want to walk through what happened in the weeks following that hearing, because the story doesn't simply end with a judge's ruling. Craig, facing the reality of a criminal referral, retained a separate criminal defense attorney and within about 3 weeks agreed to a plea arrangement with the district attorney's office, one that required him to provide a full, detailed account of exactly how the forgery had been arranged, in exchange for a reduced charge and sentence that avoided significant prison time given his lack of any prior criminal record. What emerged from that account, which Craig eventually shared with me directly during a difficult conversation about 2 months after the hearing, was a picture considerably more desperate and less calculated than I'd initially assumed. Craig's commercial real estate career, which had appeared successful from the outside, had actually been struggling considerably for the previous 3 years. A series of failed development deals leaving him with substantial personal debt that he had, out of shame, never disclosed to anyone in the family, including our father. Rachel, I want you to understand, this doesn't excuse what I did. Nothing excuses it. But I need you to understand how it actually happened, because I think it matters to whether you can ever trust anything I say to you again. Craig's voice, during that conversation, carried a rawness I hadn't heard from him in years. I was drowning in debt I was too ashamed to admit to anyone. When Dad got sick, I started thinking, in this really dark, desperate way, about the shop, about the house, about how much equity was sitting there that could actually solve my problems if I could just find a way to access it. I told myself at first that I was just exploring options, looking into what it would take to contest an estate plan I felt, honestly, had never fully accounted for the different financial situations Dad's 2 kids had ended up in. But somewhere along the way, exploring options turned into actually arranging a fraudulent document, and I let my own desperation convince me it was somehow justified, that Dad, if he'd really understood how much trouble I was in, would have wanted to help me this much anyway. You could have just told him, I said. He would have helped you, Craig. He helped me plenty of times over the years when I needed it. All you had to do was tell the truth. I know that now, Craig said, his voice breaking. I think some part of me was too ashamed to admit how badly I'd mismanaged my own career, especially compared to how steady and responsible you'd always been. It felt easier to take something than to admit I needed help, and by the time I understood how badly I'd miscalculated that decision, Dad was already gone, and there was no more chance to just have the honest conversation I should have had from the beginning. I want to be honest that forgiving Craig, in any complete sense, has been a slow and still ongoing process, one I don't think I've fully arrived at even now, several months after that conversation. What he did wasn't simply a lapse in judgment born of grief or financial panic. It was a deliberate, calculated plan to defraud our dying father's estate, timed specifically around a period when our father was too physically weakened to advocate for himself, and it required, along the way, recruiting willing or at least complicit participants in Victor Reyes and the 2 witnesses, all of whom faced their own separate legal consequences once the full scope of the fraud came to light. Sully, throughout the entire ordeal and its aftermath, remained a steady, grounding presence, the same way he'd been a steady presence throughout my father's final years. Your dad built that whole business on doing honest work and standing behind it, he told me, sitting in the shop's break room not long after the criminal proceedings concluded, in front of the same broken vending machine he and my father had joked about for decades. I think the thing that would have hurt him most about all of this isn't even the money. It's knowing his own son thought so little of asking him directly for help that he chose to fake his signature instead. The original will, reinstated by Judge Ferrara's ruling, went through to its final probate resolution about 2 months later, the estate divided, as my father had always intended, between Craig and me equally, with Sully receiving the modest bequest my father had specifically arranged for him years earlier. I made a decision, working with Harold, to formally transfer my portion of the print shop's ownership stake to Sully, alongside a small cash bequest from my own share of the estate, a decision I made not out of any obligation, but out of a genuine belief that Sully had, in every meaningful sense beyond blood relation, been more consistently present for my father over the final years of his life than either of his own biological children had managed to be during that same stretch, myself included on my harder, more distracted weeks. "Rachel, I can't accept this," Sully said when I first proposed the arrangement. "You already have," I told him. "You accepted it 30 years ago, the first day you showed up to work for a man who became one of your closest friends, and every single day since, right up through sitting with him in his final months, when his own son could only manage 4 days out of 3 weeks. Craig, once his plea arrangement concluded, served a period of probation and completed a substantial amount of court-mandated financial restitution to cover the legal costs the fraud had generated across the estate. He reached out to me about 6 months after the hearing, asking if we could meet, not to ask for anything, he was careful to specify, but simply to begin the slow, uncertain work of figuring out whether our relationship as siblings could survive something this serious. I agreed to that meeting, cautiously, and we've had several more since. Difficult, halting conversations that haven't yet arrived at anything I'd call full reconciliation, but that have, at minimum, established an honest foundation neither of us had before. One built on Craig's full acknowledgement of exactly what he did, rather than any minimizing or excuse-making about the pressures that led him there. "I don't expect you to trust me the way you used to," Craig told me, during our most recent conversation. "I'm not sure I'd fully trust myself either, honestly, if I were in your position. But I'd like the chance, over time, to show you I understand what I actually did and why it can't ever happen again, in any form, no matter how desperate I might feel in the future." I sat at my father's old kitchen table last month, going through the last of the estate paperwork with Harold, the print shop now formally transferred into Sully's ownership. The house on Marchand Street sold, its proceeds finally distributed the way my father had always intended, and I understood something I don't think I'd have understood as clearly without that terrifying, compressed week racing against a probate deadline to prove what my instincts had known from the very first moment I saw that second will. The truth doesn't always announce itself easily or on a convenient timeline. Sometimes it requires digging through old boxes of birthday cards, calling elderly neighbors, and trusting the quiet, steady testimony of the people who actually showed up, day after day, when it would have been so much easier for them not to. My father spent 34 years building a business on the simple principle that honest work eventually speaks for itself. It took a forensic document examiner, a neighbor's dated get-well card, and a foreman's unwavering memory to finally prove that principle held true even after he was gone. If this story reminded you of an aging parent whose estate planning might benefit from an independent second opinion, particularly if a new document surfaces from an unfamiliar attorney during a vulnerable period of illness, don't hesitate to seek out an independent forensic review before assuming the more recent document automatically reflects your parent's actual wishes. And if this story stayed with you, share it with someone who needs to hear it, and subscribe for more true stories about family, justice, and the quiet people who show up with the truth exactly when it matters most.